Hello, everyone, and welcome to our presentation this evening. So you are getting divorced. How about mediation? Now what? With Stephen Leskin from uh, Leskin's Law, One Day Divorce Mediation. I think I got that right. um, and with us tonight, Stephen Leskin, and I'm going to let you take that away.
It's a little hard. I can only see myself on the screen, so I don't know who's out there or if you're looking at me or like frowning or making faces. So I'm just going to talk. Um, my background is I was admitted to practice in 1992, and my first office was in Hillsborough, literally just above the old law library. And I opened my practice on September 18th, 1992. And for those first couple of months, I spent a lot of time in the law library, not looking up law stuff, but flirting with the law librarians. And eventually my law practice grew into a trial practice, and I did personal injury and divorce and Social Security disability and commercial litigation. And then around 2001 or so, I started doing almost exclusively family law and divorce. So I always kind of start when I start thinking about divorce, I start with a question, and the question is this: why is it that the lawyers and the judges get to decide how people's divorces go? Why isn't it the therapists, right? That would make sense. People are emotionally vulnerable. Why not have, things worked out through the therapists or the accountants? I mean, they would be natural people to help with all the financial issues, the big one being you got twice the expenses and half the income during a divorce. So why not have the accountants make decisions for people and just make it a financial decision? And the answer to that is that uh, early marriages were considered a contract. And you go back and you read the old case law, and they would talk about, husband's obligations and wife's obligations. And the reason that the process for dissolving a marriage ended up before the courts was because you were breaking a contract if you wanted to get divorced. And in the old days, in order to break a contract, you had to go to court. You just couldn't stop paying. So if somebody did some work for you and it was substandard, you still had to pay them until you went to court and the court let you out of the contract. And so in the old days, you had to prove fault in a divorce. And the old days go, in this case, up until about like 1954 in Oregon. And at that point, no fault divorce was introduced, which meant that all you had to do was say, we can't get along, and the court would grant the divorce. And back in those days, it was also jury trials. So you can imagine, your spouse has cheated on you, and that's grounds for default, and you go before a jury, and the jury might return a verdict of you didn't prove your breach. You can imagine the ride home in the car after a jury trial like that, and you're still married. So, anyways, the law has certainly evolved and matured, and all you need to do is allege that you no longer want to be married, and that's sufficient. You don't even have to prove it. It's just a given. If you want to be out of the marriage, the state and the courts are not going to stand in the way of your divorce. A byproduct of that, though, is that courts treat divorce like other legal matters. Courts are really good at protecting people's rights, but in divorce, it's not always rights that are important. There are certain divorce cases that absolutely should be litigated, and I'll cover that in a little later. But it's in 90-80% of the times that people are divorcing, it's overkill. You don't need the insistence on protecting every single right that a litigant has in a divorce case. And so that's one of the things that contributes to why divorce is so contentious, expensive, stressful, and crazy making about the courts. So, like I said, I've been a litigator for a long time. I've tried a lot of cases in the Tri-County area and all over the state. And so I've seen the dynamics and how the dynamics play out. Like I was saying, courts are really good at protecting rights. They're not always really good at getting people to court. There's a lot of delay in the system. There's a lot of delay built into the system. So court cases, the divorces that end up before a judge can take a year, 9 months to a year overall to get to a judge if you can't resolve the case yourself. So you have that crazy dynamic of overkill in the courts. And for example, courts require an exchange of information, and parties can say we don't want to do it, and you don't have to. But if one of the parties says, "I want to see, 3 years of your tax returns, 3 years of your bank statements, 3 years of your credit card records, 3 years of uh, um, all your partnership agreements, uh, business records, anything potentially related to the divorce, you're obligated to provide that." And that gets me to like we're talking now about like why the courts are so crazy about divorce. We're talking now about like why the lawyers are so crazy about divorce. So the lawyers will still, it's if somebody asks for it, you have to provide it. And if somebody asks for it, then I'm obligated, the other side is obligated to ask for it. And a lot of that work is it's done in good faith, but it's not necessary. The courts, the work generates itself, but the end product is very rarely useful. And so litigants can spend thousands of dollars in legal fees doing work that's potentially helpful, but not necessarily helpful or not necessarily going to provide information for court. So, for example, you request your spouse's bank records for the last 2 or 3 years, not uncommon, and you go through them and you don't find anything that you can really use in court. Okay, so you found that your spouse is spending for pornography. Nobody cares. Nobody, it just doesn't have any bearing on the case. The only time it could have a bearing on a case is like, if it's child porn and there's a custody issue. But other than that, those kinds of like embarrassing character things, nobody cares. It's not relevant to the divorce. So the only things that are the purpose of the divorce, let me explain. It's not relevant because the issues in any divorce are going to be division of the assets and liabilities, uh, making provisions for the kids, and future income. So in the form of how that will be divided if there's an argument or an allegation that one of the spouses is entitled to spousal support. So those are the three issues in divorce. And like the character issues of like what you're spending your money on, unless it's something really, it doesn't matter. So the attorneys are obligated to do work that doesn't really count to moving the case forward, but you got to do it. And if you don't do it, and then something turns out that you missed, you might have a malpractice claim against you, or maybe an ethics complaint for neglecting a case or something crazy like that. But that's one of the reasons that the way the court system developed to handle divorces, why it's so dysfunctional. And there are plenty of other examples like that, but that's just like it just always like sticks in my craw when I'm doing it for clients that can do a lot of work. It's going to cost a lot of money, but I can't really promise you that it's gonna work out or yield information that's going to help your case. There's also another crazy dynamic about taking a case to court, and it's it's nuts. I charge when I litigate, not when I mediate, but when I litigate, I charge $300 an hour. That's a lot of money. I know it's a lot of money. That's what it costs to keep my doors open and pay my salary and my assistant's salary and rent, overhead. That's what it costs. Uh, uh, so if you're the wife, you're paying me that much money, you expect results. And those results mean that I'm fighting with your spouse and your interests are adverse. So if it's a spousal support argument, even if the other side is reasonable, you're paying me money to see results. And that natural, reasonable, completely warranted expectation is just pushing both sides to fight more because they want to see that their money is being used and spent. So it's just the way it is. It's like you don't want your money that you're giving your lawyer to be just going out the door. You want to see some results for it. So if like just continuing with the spousal support example, if husband says, I want to pay, I'm only going to pay 1,000. Well, maybe that's a reasonable. I don't know. Maybe that's a reasonable number. But wife says, no, I want 2,000. you're going to be fighting over that, and you're going to be expecting results over that. And so that 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 push and that spending of money exasperates not only the stress and the aggravation, but the tensions in the case. It's just a dynamic that's inherently built into the case. So I've had all of these criticisms of the legal system and how divorce is practiced for a long time. I started to say I opened my practice in Hillsborough in 1992. I've been doing divorce since 2001. I had a break in employment about 5 years ago, and when I came back to self-employment, I decided that I was going to do divorce differently. And I'd been mediating cases for 20 years, 25 years, and I thought I want to I want to work through the divorce process better. And so I started putting together my own divorce program. And I'll come back to that in a little bit. But the alternative to litigation really is mediation. And um, I'll come back to that a little bit. The end result of any the end result of any divorce litigation, divorce process is going to be the general judgment of dissolution. And that's the final document. That's the only document that really matters. Everything else is either motions or documents that the court needs for information. The only document that really counts is the general judgment of dissolution. And it doesn't matter how you get there. The courts don't care how you get there, but how you get there matters. And there are a couple of different ways that you can get there. One um, is you and your spouse can agree on everything, and you can have an uncontested divorce, and you can something like that. It's perfectly reasonable to download the court forms and fill out the paperwork yourself and turn it into the court and pay the filing fee, and then the judge will sign the general judgment of dissolution if everything is according to statute. Uh, that's really appropriate, like when there's not kids or a house or complicated retirement accounts. Those things just require technical knowledge to be able to do right and to get right with the court and to produce a document that's going to work now and in the future. The uncontested divorces and the forms for the uncontested divorces are for people we're just done. We can walk away from our marriage and we don't really need anything from each other. There's really nothing to share. There's no debt that needs to be paid. There's no equity in a house that needs to be divided. We're not going to transfer um, equity from a retirement account. So the uncontested is, in my view, really only appropriate where the couple's going to walk away from each other. The forms are complicated. I sat on the state form committee for years, and I know how bad the forms are. I've had discussions with judges about how bad the forms are. There's language in the state produced forms that I don't understand. And I've had this conversation with judges where we're just kind of like, what does this mean? And it's like, I think it means. So, if we can't understand it, chances are you're not going to understand it. Chances are you're going to fill it out wrong. A good portion of my practice used to be people who filled out their own forms and got it wrong. And then, um, can you help us? And it's like, well, you could have paid me the first time. It wouldn't cost as much. So you can do uncontested divorces. Um, Let me just give an example. I had a phone call with somebody just the other day who was doing an uncontested divorce, and they owned a house and they had $200,000 in equity in the house. And the only part of that they dealt with was the house was that husband and wife would continue to pay half the mortgage, right? So they didn't deal with the equity in the house, the $200,000. And now they wanted to sell the house and there was no guidance on how to do it. Whereas a competent a competent general judgment dissolution would have laid out specifically, this is how we're going to sell the house. These are the deadlines for things to happen. This is who we're going to use as the realtor. This is how the payments are going to be made. This is how we're going to deal with repairs to the house. And it just would have gotten done correctly by, any competent lawyer. Any divorce lawyer would have dealt with the house correctly. So you can do, not discouraging people from doing uncontested divorces in the appropriate situations. Likewise, another inappropriate situation would be if there's kids. Kids are particularly complicated to deal with in the divorce setting. The three issues to deal with the kids are custody, parenting time, and child support. And they're just dealing with the child support calculator is confusing. You can find the child support calculator at the Oregon Department of Justice website, child support division, and you just put in the numbers and it gives back a number that's child support. But it's just a complicated thing to get the judgment together and all documents together. And then the third thing is putting together a parenting plan. And uh, sometimes just having somebody who's been down the road a bunch of times and knows what the problems are will just forego a lot of heartache in the future. And understanding what the terms mean and when you can vary from it, and when you can modify it, when you need to go back to court to modify it, just having somebody in your corner to do that with, it just goes a long way to reducing stress and anxiety. So those are the circumstances that I don't particularly recommend doing uncontested divorce. So that's one way to get to the end result, which is the general judgment of dissolution. Another way is default. You can file a petition for divorce, and the other side, your spouse, not show up. In that case, you can take a default against them. If they don't appear within 30 days of being served with the summons and the petition for dissolution, you can go to court and file an order, a motion for an order to default, and then the general judgment by default. And that's another way to get it. Related to uncontested divorce is a stipulated judgment. And that's where maybe lawyers are involved and the parties come to an agreement. And by far, most judgments are by stipulation, right? So you've gone through some process. Maybe it's mediation, maybe it's litigation and settlement talks. Maybe you've had a judicial settlement conference with a judge at one of the courthouses. And you and your spouse agree to all of the terms of the judgment, then it's stipulated. And then the last way to get to the general judgment is by going to trial. And that's where both sides show up. Maybe you have attorneys with you and you put on your case and the judge decides all the issues. You call your witnesses, you submit your documentation, you have the right to cross-exam, and the judge, in the end says, this is what I'm going to do. And then one of the parties is assigned the task of drafting the general judgment, and that's just called general judgment of dissolution, and that puts an end to the case. And that I don't know what percentage of cases are decided by stipulation or by trial, but in my legal practice, most cases settle by stipulation, or maybe you get to like some point of agreement on some issues, and some issues you can't, like for example, the amount of spousal support or the duration of spousal support. You agree on everything except that, and then you take that to the judge, and the judge says, well, it's going to be 10 years at $2,000 a month or whatever. So those are the ways that you get to the general judgment. So the reason I'm droning on about that is because the other way to get there is through an alternative dispute resolution technique. And they're really two techniques and then one hybrid. And the hybrid combines the two. So it's not really a separate hybrid. It's the same. It's just the two combined. I don't know if that's clear. So one is arbitration and the other technique is mediation. Arbitration is a mini court hearing in a private office with an arbitrator that the parties select themselves. So the husband and wife, or whatever the combination is, can say, we want to use this attorney to arbitrate, and then the parties both come in, they present their evidence and documentation about the property, the value of the property, what the debts are, whether there's going to be spousal support, and the arbitrator makes the final decisions. And if you're going to go that route, it's going to be binding. it will be binding arbitration. And then the arbitrator will, or one of the parties will put together a judgment, and that will, and the parties sign it as a stipulated judgment, and then that gets turned into the court and filed with the court, and the judge signs off on that, and then that's the general judgment of dissolution. Okay, so all of this has been working up to divorce mediation, right? And that's the other technique that the other alternative dispute resolution that I now do primarily. And divorce mediation is a structured, the mediation is a structured conversation in search of a solution that the parties fashion themselves. It tries to create win-win solutions, not lose-lose, or I lose, if we're both unhappy, then we got it right. No, mediation says we're going to work together to get the solution given our resources and our situation. And the mediator will meet with the parties and separately, and then talk with them, get to know them, get to know their situation, and then go back and forth between husband and wife on each of the issues until there's a resolution on each of the issues. It's not the arbitrator, I misspoke. The mediator's role is not problem solving. It's not advising this is what a judge would do. It's not, I think that this would be fair. That's not it. Mediation is the parties coming to their own agreement about what they believe is fair. The arbitrator's role is to serve as an impartial facilitator, an impartial, neutral facilitator. And that's the skill, the mediator's skill is in getting the parties to move together towards a solution that they can both live with and that will work for them going forward. So contrast this to spending a day in court and then having the judge decide the issues, like, for example, parenting time. Supposing the issue is parenting time, who's going to know your situation better? The parties, the parents. Parents are going to know the kids. The judge is never going to have met the kids, or the parents who just, in 90% of the cases, both parents have their kids' best interest at heart, and the mediator will help move them in that direction that works. They can each have different views of what best interest is in good faith. That's fine. That's what makes everything work is those differences, because that's what it is. But there's nothing wrong with that. And so the mediator's role is to find where the interests are that overlap, where there can be agreement. And so that's what mediation does. It's a talking process to get the parties to a solution that works for both of them over time. I mentioned that there was a hybrid solution. I misspoke. A hybrid technique, and that's mediation coupled with binding arbitration, and that's actually what I do. So in my cases, I will work with people for a set number of hours. At the end of that day, if the parties can't agree, then I step in and act as judge and apply Oregon law to make the final decisions with people, for people. And I have to say, for as long as I've been doing mediations, that's really never happened. My process is really good, and people get to their own solutions, and many times they'll get to their own solutions before the mediation, which is, to me, just validates that what I do works. I want to switch now to some practical issues, and then we'll wrap it up. Most of my practical issues are going to be how to prepare for mediation and just things to think about. And I'll go through my process a little bit during this part of the talk too. So one of the first, excuse me, I got an itch right here. So one of the most important criteria, one of the most important what's the word? One of the most important considerations of whether or not you should mediate. Mediation is not appropriate in every circumstance. And some of those circumstances would be you don't trust your spouse, right? You think that your spouse, you have a good reason to believe that your spouse is hiding assets or income or debt. Mediation itself is not a fact-finding process. In litigation, right, where you hire an attorney and you litigate before the court, the attorney has the power to subpoena records. So if you think that a spouse is not disclosing all your bank records, the attorney can send a subpoena to the bank and get everything that you need. Um, or the subpoena can notice the parties for deposition, put somebody under oath and say, have you disclosed all of your records, all of your financial records? And then that's a sworn statement. It's under oath. So you're obligated to tell the truth, and there are penalties if you lie about that. So if you think that your spouse is hiding assets, debt, or income, mediation is not appropriate. Another case where mediation is not appropriate would be where the parties can't contract. They legally or don't have the capacity to contract, and therefore they can't enter into an agreement. So, for example, if somebody is intellectually or emotionally compromised, not appropriate for mediation. I tried to do mediations um, where there was a guardian in place of the person mediating, and it wasn't a great situation. So in those cases, um, the courts are probably a better venue. Cases where there's been a long history of violence are usually better litigated than mediated. Um, if there's some abuse in a relationship, mediation may work because the mediator will filter out, or at least the way I do it, will filter out the ad hominem and filter out the manipulations and just bring the other party, uh, uh, the abuser's positions on issues, right? And so all you're hearing and all you're dealing with is the who's going to get the furniture in the house, right? And so um, if that's all you're dealing with, then you can focus on what's important, and that's getting the settlement that works for you. Uh, and so in certain circumstances, um, an abusive relationship might work in mediation, but if there's a lot of physical violence or years of physical violence, then the abused really needs an advocate and needs to listen to that advocate and trust that advocate, that the advocate has the person's best interest at heart. Another issue, it would be, now other mediators disagree with me about this, but I will explain my reasoning, is if child support, I misspoke, is if child custody is at issue and there's allegations of child abuse or there's been DHS involvement. I personally, I don't want to be involved in mediating a case on child custody where there's abuse. I just don't want to partake in that. I mean, I think it's not a fact-finding process, and the court has to have all of the information, and not all of the information may come out during the mediation. And if there's an abusive relationship that or dynamic that I'm not picking up on or party can't articulate, then it's better left to somebody who can advocate for um, either the mother or the father having custody. It's just too important a decision um, to not have all of the facts in front of the decision maker. So those are a couple of the. Another one would be um, complicated financial instruments. Like a lot of times, um, especially in Hillsborough, people have very complicated um, financial retirement accounts or financial accounts that will need an expert to value. And so sometimes having two attorneys and the pushback between the attorneys will help get that right. It's not always appropriate for mediation. The same with business valuations. If there's a complicated business valuation, mediation may not be the best form. It may need an advocate who will really delve into like how are we going to value this correctly to get the right division. So those are a couple of instances where mediation is not appropriate. Um, so I'm going to just quickly pivot to how I work, and then I'm going to get into the part that I just mentioned, just really just like practical things you can do to prepare for mediation. So um, I spent years litigating and know that the system doesn't work. It's too expensive, it's too time consuming, it's too stressful, it's overkill for what 90% of the people need. And so I sat down and I spent years thinking about how do I make divorce better for people? How do I make it less onerous and less stressful? And so the way I work is after both spouses need to sign a participation agreement. I set a flat fee based on how complicated the marital estate is. And then we set a date for a pre-mediation conference and the mediation all in right at the front, right at the start. And so people will know exactly what date their mediation is going to happen on. I set a flat fee. It's a one-time fee. There's no other costs. Um, and uh, it's just it. It gets paid at the front, and then you're just done worrying about money. It's not like a lot of litigated cases where I'm going to work 3 or 4 hours a month on your case, and I'm going to send you a $900 or $1,200 bill every month until the case is resolved. And then it's going to be a lot more when we're getting ready for trial or depositions or whatever. So I set a flat fee. It's a scaled fee depending on how complicated the marital state is. And then I collect information online about like bank accounts, debts, middle assets, the vehicles, retirement accounts. Uh, that's collected online, and then both the parties get to see it, so they know. So there's complete transparency, and so by the time we get to the mediation, there's no fact issues about how much is in a bank account or how much debt there is or what the market value of a house is. We've worked that out at the pre-mediation conference. The other thing I do, and I'm pretty sure I'm unique about this, I do at the pre-mediation conference is I explain the law around all of the issues that are going to be decided at the mediation. So people aren't grasping for, well, what's fair, right? It's like, here's the law. When you guys mediate, when we sit down and talk together, you'll have like some guideposts to know what a fair settlement is. And I've just found that that makes all the difference in the world. People aren't don't have the anxiety that they're getting taken advantage of. They know where the guardrails are, right? So I spend a lot of time going through at the pre-mediation conference. This is what the law, what Oregon law is on this particular topic. So if it's spousal support, I explain this is what spousal support is supposed to accomplish, and this is what the courts can do for a spousal support award or not, or division of the assets and the debt and how that gets worked out. I explain all of that in depth at the pre-mediation conference, and people who hire me also get a comprehensive a guide to mediation that explains the law and how the mediation works. So we do the pre-mediation conference and then we do the mediation. And I kind of explained what the mediation was before that. I go back and forth, the mediator goes back and forth until the parties arrive at the appropriate solution for their circumstance and for the resources and what they have available to them. And that process can take a couple hours. It can take all day. Like I said, the way I do it is if at the end of the day, parties can't agree, then I make the decision. So people are done within a day. And then I do the paperwork and get everything filed, and I pay the filing fee out of my fee. So that's the way I work. And the reason I tell you that is when you start to look for a mediator, ask them how do they work? What's the process? And knowing how mediators work, if you're decided on mediation, ask how do you go about this? My process is designed to be efficient, fair, transparent, affordable, and I put a lot of effort into creating a system that works, and it does work for people. All right, so let's talk about some practical things you can do to prepare for your divorce mediation. And I've been speaking for about 35 minutes now, so I'll go for about another 10 minutes, and then we'll open it up for really good questions. All right, no frivolous questions. I just want to hear good questions. So one of the first things That's important, especially if you're living together and the spouses are living together and they don't think they're going to be living together, is gather your documents, right? Make sure you have access to your tax returns, bank statements, credit card statements. Like I said, you're going to need those values anyways. If you're going to mediate and you believe that your spouse has been dealing with you in good faith, then you only need the most current month. If you're going to litigate, then you probably are going to be asked to provide a year of bank statements, a couple of years of tax records, credit card statements, and things like that. So, um, first thing is gather your documents. Under the same heading is there's two specific documents that you should gather in any event, whether it's mediation or litigation. The two documents are your current credit report, so you can see if there's credit cards attached to your name that you're not aware of. Um, and so you want to make sure that, there's not an American Express card that you didn't know about, but it's in your name. So free credit report, you get that online. It's easy enough to find. The other thing is if there's any issue that spousal support is going to be involved in, for example, like calculating child support, I suggest going to the Social Security Administration website and requesting your earnings report. It's easy to do. It's free. You get it within a couple of days. I don't think they send it out online. I think it's all through the mail. But that's the authoritative statement of what your earnings have been over time. And that will help with both child support calculations and spousal support calculations if those are issues in your case. If there's a business, like suppose like one of the spouses owns a business, you want to gather uh, documents like the partnership plan, the articles of incorporation, bylaws. All of those will deal with how interests are going to be divided. So those are important. If you own the business with your spouse, that's considered a marital asset, and um, even if one of the parties, uh, even, let me just, even if one of the parties um, has like a 90% interest in the other 10, the business is still considered a marital asset and subject to be split um, evenly. Um, so you want to gather your business documents. In anticipation of a divorce, you want to make sure that you have all of your passwords and social media account logins, and you want to change any joint passwords so your spouse can't read your correspondence with your attorney. So you want to make sure that your privacy is protected. If you um, have been a stay-at-home parent and your spouse has worked and you're getting divorced, you need to prepare a budget with real numbers. Not, I'm going to have this much money. You need to produce a no nonsense, no BS budget about what your numbers are. And that's important for your own planning. And it's important if there's going to be spousal support. Like I talked about a little bit earlier, you can go online to the child support calculator and figure out what your child support's going to be. So you have that income number. Um, but you need to have a budget. You need to know what your money is going, where your money is coming from, and where it's going to be going. Um, if there's a home that's involved, you're going to want to make sure that you know who has who's on the mortgage. Is it both of you? Is it one of you? Is it one of you and a third party? Are there any liens against the house? Has the house been used for collateral? How much equity is in the house? And just to clarify, equity is market value minus what's owing. That's equity, and that could be for anything, but that's the general definition of equity. So you can go online and look at Zillow or Redfin and figure out, a pretty good ballpark of what the market value is. Um, so those are does the house need repair work? You want to do a budget for, how much repairs are going to be needed. Talk with a realtor about getting those repairs made. Maybe you can find a worker who's willing to work on and get paid out of the proceeds of the sale of the house. So that's possible. If the house is going to be refinanced, this is really important. If the house is going to be refinanced in one name only, so both spouses are on the mortgage, one of them is going to get the house and buy the other out, right? Maybe there's $100,000 in equity, each is entitled to 50, and so the other spouse is going to pay 50 for the house. You need to start working with your bank early. There may be language that needs to be in the judgment that the bank needs, and there are going to be time factors that have to happen before the bank will release the money. I'm not going to speak to that, but you'll need to speak with your mortgage person about what are the criteria for buying out a spouse, and that may need to get into the judgment, and will definitely need to go into your thinking about um, how you're going to deal with your spouse. Let's see what else. Children. Um, I don't think I have to say this, but I'm going to. Um, unless things are really bad, you're going to need to plan to deal with how you're going to explain it to your kids and how to minimize the impact on their lives. That's obvious. I don't need to say that. But you're going to start needing to think about the parenting plan. Some people think, well, we'll keep the kids in the house and mom and dad will just move in and out. You can try that. I've seen it. It doesn't really always work great. It means that there's three properties instead of two. So it's not always financially viable. You need to devise a parenting, while 50-50 often is the desire of a lot of parents. You have to figure out if that's actually doable and financially you're capable of doing it. And that depends on your own circumstances. It's great if it can happen that way, generally. But there, you got to be really realistic. Is that possible? Um, you put together a parenting plan. You start to think about the parenting plan. The parenting plan is a guideline. It's the rule book. And if you're getting along great, you don't need to pay attention to it. A lot of couples after the divorce, a couple months or a couple years after the divorce, they're parenting fine together. The parenting plan doesn't matter. But if there's breakdown in the relationship and the breakdown in the relationship continues and you can't parent together, then the parenting plan um, says this is the way you're going to do it. This is what we agreed, and I'm going to go to court to enforce it if you're not living up to it. So that's the way you think about the parenting plan. You want to think about it. You're going to want to, if you're mediating, when you're mediating, you're going to want to think about what your positions are ahead of time. You're going to want to think about what's the best interest of the child, what's your interests, right? You want to deal with your interests and values and how you're going to convey those during the mediation to your spouse so that you can work together so that you both of your needs are met. Um, and then this is not really so much for mediation, but I'm just going to talk about it anyways. If you're preparing for a custody battle, you don't think that your spouse is capable of um, both the parties want custody. You're going to create a log and you're going to start documenting the things that you do with the child or children. You're going to keep notes on the kid's interaction with your family, with his family, doctor's appointments, friends. The Oregon Revised Statute gives criteria for what court needs to look at in making its custody decision. Your lawyer can go through that with you, but you want to create a log to do that, and the sooner you start it, the better. Photographs, recordings, all that stuff, text messages between the spouses and the kids, all that can come into evidence. So you want to start collecting that. That's more for trial than um, mediation. The other things you're going to want to think about are how you can divide the personal property. It's going to get divided. Who's going to take what? You want to start thinking about what's important to you, what's the sentimental objects about you, to you, what's going to happen to the pets, if you have pets. Some other things to think about are, do you have common accounts? Like a lot of people have common cell phone accounts. What are you going to do about that? How you can divide that? You're actually not going to divide it. You're going to split up. So you want to start thinking about your own accounts. The purpose of the divorce is to divide you. So you're not going to continue to have joint accounts. And then if there's estate plans, right, you can have wills, you're going to want to start thinking about um, undoing the wills, changing your beneficiaries on life insurance, um, and other employment related benefits. You want to make a list of all of that and go through and start changing that too. So those are things that you can start to do in anticipation of divorce mediation and litigation. So I have been speaking for about 45 minutes, and I would be happy to entertain questions